lecture. I also had the opportunity and the pleasure to read a chapter from the forthcoming book, and so that would be the kind of subject matter of my comment, which is an extended version of that lecture. And also thank you, Leora, for asking me to comment on this chapter, which is really terrific and very interesting. And I'll just say, as I said before, it gives rise to many important questions, kind of the ground questions about morality versus law, and many different questions, private law, public law. And so there is no way in which I could do justice, let alone reparative justice, to this paper. So I'll just say, I think two different sets of comments, questions. Some of them are kind of more invitation for you to elaborate on, and some are kind of more critical. One is on the concept of reparative justice and what work it does in your work, and the other sets of questions and comments will be more kind of jurisprudential or general kind of question about, because the way that I would kind of title my comment for would be not just about the problem of the past, but the problem of law. Right? I think there is a challenge here for about the identity of law, what to make of law, and how law works. All the kind of questions that we, I think everyone in this building are kind of engaging with constantly in different levels, different dimensions and intensities, but I think those kind of cases kind of push a bit harder on all those questions. So let's start with reparative justice. And here it was a bit puzzling to me to think about the situation here. So my question, one way to put it is, can reparative justice lay claims only for compensation and restitution and not for any kind of super compensatory damages? And so the question here about reparative justice is the kind of the suspicion is that when someone does some terrible stuff, right, in the indigenous residential schools and other cases, forced labor, right? So I would take Leora and force her to work for me, right? And then she would come to court after, and there would be kind of procedural hurdles, whether she could sue me or not, and all this stuff. But when I have to pay the restitution, isn't it just a case of the court legitimizing, authorizing the forced sale? Right, so I think that the deeper question here is, and the same goes with the indigenous victims, right? They would be compensated for pain and suffering, for many different kind of non-pecuniary laws, and also for pecuniary laws. But it seems that one kind of suspicion here is whether the court is actually providing a kind of a secondary market service of putting prices on kind of the behavior, the past behaviors, right? By compensating you only for the pain and suffering, and only for the kind of work that you did forcibly, isn't it the case that now compensation is a form of authorizing laundering injustice rather than doing justice? So there are many kind of in the literature, it's something called the question of commodification, and so I think the deeper question here is that it seems that there, in my view, at least, there are two different dimensions to the basic rights that we have and for which we sue those tortfeasors or wrongdoers. One is the one dimension is kind of captured with compensation for pain and suffering, restitution, which is the well-being aspect. So all those kind of horrendous wrongdoing is a kind of impairment of our well-being. And so because I suffer for that, I just want to be compensated. So that's one dimension. But it seems that the question is, can reparative justice say more about the second dimension, which is, I would just tentatively call it dignity, right? So there is something wrong, not just about forcing it to work without my consent and then paying, the market sum. What would it mean? But something that would compensate or convey a sense in which it was wrong to do so, and that would be the dignity aspect of my right. So in addition to well-being. And so the question for justice, for reparative justice, is how could we understand those kind of compensatory awards just in terms of focusing on the well-being they mentioned. Now, one perfectly sensible response would be that there are some kind of second-order consideration, like economic constraints, political constraints, that it's just enough to pay $6 billion, we couldn't afford more, or perhaps there are alternative ways to convey this super compensatory damage. It doesn't have to be punitive damages or those kind of super compensatory damages. It could be an apology, for example, or some other something that is not just chipped off, that conveys the message that it's not only was the diminution of my well-being, but it also was kind of an affront on my dignity, and so the government should do something in order to rectify that dimension of my right. So that's a question about reparative justice, and what the kind of claims that it lays in those situations. Another point on reparative justice, which is preempted by Leora before, she asked me, you would ask it, so, and that's right. But yeah, so what's the role of private law in this? So you can think about reparative justice as a kind of a general form of justice, and private law is just a doctrinal book on which we could execute that form of justice, make it. That's one instantiation of this form of justice. It could be others. Perhaps we don't even need the law sometimes. Perhaps or perhaps we should not need the law in a perfectly just community who would just compensate without forcing the government to kind of admit that something was wrong, right? So the question is, what to make of private law? And I think one way to kind of, one practical takeaway point of that question is the question about the scope of those claims. So the government is, I think, the most immediate, let's say, defendant in those suits, and we could extend it to the church. What would be the case with private individuals, business organizations, or other cases? So I think the question of private law, what exactly private law is doing in this story, perhaps may also affect the way in which we could understand what's the scope of those claims and what's the identity, the right way to identify what's the identity of the potential wrongdoers that we could actually sue them, even given that we have all those kind of statute of limitations and other procedural and substantive errors. So that's another question about reparative justice. The other set of questions is a more kind of jurisprudential, political, philosophy kind of questions that are really different from the former ones. And here, just to make a clarification, because I think that Professor Moran said it, but it's more kind of, there is an elaborate discussion in the chapter that I've read. And so, and this is especially, I think, true in the case of slavery in the US, and also the Canadian case of the indigenous residential school, which was, it was legal, right? It was even constitutional to enslave people in the US. And it was legal, and in fact that was the intended end of the Canadian government, to re-educate those people, right? And so I think this is exactly where all those kind of, I think, very interesting questions, the grand questions about what law is and what's the purpose of law and what to make of law, really kicks in those various situations. And so again, there are many ways to kind of flesh out or to invite you to elaborate on them. So I'll just make two. One is the kind of debate between natural law and positive law, right? So when I read the piece, the part on the Canadian case, it seems like this was a case in which Dworkin would have said, I said it all along. That's the right way to think about law. Right, so Dworkin had written, I think, in various places, including in the New York Review of Books, that slavery was unconstitutional from day one. Not just in the matter of morality, but that's the right way to think about law from day one, right? Because he has this view that law is just the institutional aspects of morality. So there is no real separation between law and morality. And so even though courts in Plessy and other cases thought that it's just a law that I could treat a person, if this person is black, as a property. He said, no, it cannot be the case. It's inimical to the very idea of law to think about this in this way. So one way to kind of understand how it is that even though the Canadian case and slavery was considered part of the positive law, it's still the case that we could sue in law for those violations because the right way to characterize what law is all along is in terms of this natural right or natural law view. That is, there is constantly two different layers in law. One is the law as posited, but there is one that is kind of overarching or something that may override the law as posited, which is a set of natural rights that are so fundamental and basic that no government and even the people cannot change, right? So that's the idea of basic human rights. And so if that's the case, the Canadian case is, I think, a very nice proving ground to kind of discuss the debate between what law is and debate, the kind of internal debate that never shifts, which I think is very, very important about the nature of law, right? It's here. That's the kind of events that people who teach jurisprudence kind of look for. What's the practical take points that we can make out of all those abstract debates, whether law is just social fact or there is something more to law, and so those are kind of, and the deeper argument, as you said, what's the kind of lessons for lawyers and judges, it seems that those people who are involved in those commissions and thinking about what we as lawyers should do about it, in one way or another, they do, and implicitly, work with a set of assumptions about what law is, right? When they make the claim that, of course, we have a legal obligation, not just a moral one, to compensate. It seems to me that there is a kind of a hidden assumption here about what they think about the law, right? So it's interesting to see how very kind of abstract theoretical propositions about the nature of law really have real practical bites in all those questions, right? And I think that's especially true with respect to both slavery and the Canadian case, because it's not just that limitation. Again, it was just pure legal to do those kind of issues. So this is one kind of question about jurisprudence and about what to make of our understanding of law, and that's a problem for the law, right? The law, the Canadian law, the US law, would need to face up the question what law is for them, right? In order to understand whether slavery can generate a claim, a legal claim against those who violated the natural rights that all those enslaved people had all along. The other one is, I would say, also kind of a jurisprudential one, which is that, another way to kind of, especially with respect to the indigenous residential schools and the slavery cases, which is that I think when we enter law school, usually we kind of have this idea, or we are taught, that there is a kind of a certain hierarchy in law in which you have constitutional norms, and then you have statutes, and then you have common law or administrative orders, and one way, or the way in which the courts would resolve tensions between different norms is kind of a formal one, right? The mechanism would be to identify the different hierarchies of those different norms and to settle those tensions by reference to that hierarchy, right? And what those cases, what is the Canadian case, shows that even when those basic rights the indigenous people had, at least the positive law right, I would say that was a kind of the common law, right, the tort law, right, the torts of battery and assault, they are not part of the statutes, let alone the Constitution, right? But even though, even if that's the case, we do see that by the end of the day, we do recognize them as having some superiority, even over statutes and other kind of legal norms that formally should prevail, right? So, and so I think those cases are, again, a good proving ground to revisit or rethink those kind of very naturally assumed way to think about the law as in terms of this hierarchy between constitutional law, statutes, common law, and so forth. And it seems that at least in those cases, when we press real hard, we find out that there are certain basic rights that no matter where they are kind of classified, they may prevail, right, regardless of the place. So it just seems to be really fascinating to think about those questions by reference